Good morning. Welcome to the Burr Forman Morning Drive. It's Friday morning, June 18th. Hopefully you are settled in with some coffee or tea and ready to learn about immigration today. My name is Melissa Azallion Kenny. I'm a partner on the Burr Forman immigration team, and I'm joined today by my partner, John Eggert. We practice in the area of immigration and labor and employment, and we look forward to sharing some information with you today about current immigration issues. At the bottom of your screen, you will see a Q&A box where you can type your questions that you might have. You can also use the chat box, and John and I will certainly try to monitor those as we go forward today. I also wanted to let you know that we have both an immigration podcast and an immigration blog, and we try to keep those up to date. Our immigration podcast is called Immigration Insights, and you can find information about the podcast and blog on our website, burr.com, and also at Apple Podcasts. So let me sort of introduce our topic for today. John and I have tried to put together some topics based on questions that we've been getting from clients. And, really since the COVID-19 global pandemic began back in March of 2020, or perhaps earlier, there have been lots of immigration developments. Some of those are direct results of the COVID-19 pandemic, things like travel restrictions and travel bans, which we're going to talk about today. Others have come about maybe due to different priorities in presidential administrations or with Congress. So, we had the Trump administration who, was really proposing lots of different things about the H1b program and maybe what some of us would consider more restrictionist immigration policies. Then we have the Biden administration who tabled many of those proposed changes and really have been focusing more on things like comprehensive immigration reform. So it's been an interesting time to be an immigration attorney, but I also know that it's been an interesting time and a challenging time for many businesses who are dealing with immigration issues. So we look forward to talking with you today about some key issues.
Right, and thank you again for attending today. Like Melissa said, one of the kind of key topics I think that we're getting questions from clients over and over and over again is on travel, specifically dealing with the COVID-19 travel restrictions that were put into place by presidential proclamation. So Melissa, why don't you talk a little bit about kind of the current status of those presidential proclamation travel restrictions? Kind of, are they still in place? What's their current status? And are there any real kind of workarounds to allow your employees to be able to travel internationally right now?
Sure. So I think the main presidential proclamation that businesses need to be aware of is 10-143, or what used to be 9993. And what that proclamation says is there's a travel ban to the United States for those who have been physically present for a 14-day period before entering the US in certain countries. So this started back in early 2020. We saw the first travel ban restriction from China. We have then since seen restrictions from Iran, the Schengen region, which includes many countries, UK and Ireland, Brazil, South Africa, and most recently India added at the end of April. And the reason these countries are selected is because of COVID-19 rates and risks that the administration believes that perhaps people present in those countries bring if traveling to the US. Now, it's important to remember that nationality has nothing to do with this. It's really, are you physically present in those countries? There are some exemptions, and that's really important. And that's really where I think most of our work comes into play, working with clients, trying to figure out how to work around the travel bans. But there are exceptions for US citizens, green card holders, immediate family members of those folks, people that are coming maybe due to a public health response related to COVID-19, humanitarian reasons. And then there's this other sort of broad category called the national interest, those that are deemed to be in the national interest. And, that's kind of been a fluctuating standard over the past couple of months. In March 2021, we saw a revision to those, what we call NIE or NIE standards, where the way to qualify for the NIE was to demonstrate that you were providing vital support to a critical infrastructure sector or critical infrastructure linked to the supply chain. And so there's a very comprehensive government document that maybe you might find at cisa.gov, and it talks about what those critical infrastructure industries are, things like critical manufacturing, transportation, water and wastewater systems, so a variety of things. But if an individual or a business on behalf of an individual is able to demonstrate that somebody's providing vital support to critical infrastructure, they're likely going to qualify for the NE. Now, what we saw in late May, and this is sort of the latest and greatest on the travel ban, is there's yet another revision to that standard. And now those providing vital support or executive director that are going to be providing significant economic activity in the US can also qualify. So that's getting a little bit away from or in addition to the critical infrastructure argument. So maybe somebody coming to invest large sums of money into the US, create US jobs, something that they might be able to argue is significant economic activity, would now be able to qualify. The
Right.
other, go ahead, John.
Go ahead. Oh, yeah, I was just going to say, I think that's important for individuals that are on an E2 visa, because I think it kind of flows nicely into that providing significant economic impact that, they've made a substantial investment in the United States, and that's why they're eligible for the visa. But
yeah, that's a great point. I mean, it used to be before those standards came out that e-visa holders were automatically given an NIE. And then with the change in March, they were sort of taken off the table. So I think you're right. I think that significant economic activity standard could really help those e-visa holders.
Right. So you talked about kind of the requirements and how you qualify for these NIEs or these NEs. Can you talk a little bit how kind of the procedure and how you go about applying for them?
Right. It really depends on whether you have a visa or not. If you have, sometimes we have business visitors coming in, maybe on a B1, B2 or ESTA, and they already have the visa or they already have the ESTA approval. And so now they think that they qualify for a NE. In those cases, what that typically requires is just an email to the consulate or US embassy or consulate where you're located, where you're going to seek or apply for the NE. And you can send a simple email. Usually you wait a couple of weeks. Some consulates are processing more quickly, maybe a week. Others are 2 or sometimes 2+. And you get an email indicating that you qualify. The other way, if somebody doesn't have a visa, is when they schedule their consulate appointment, then they would actually be prepared at that time to also advance the NE argument. And the way that that's typically done is through a detailed letter that outlines the various reasons that they're coming and why they think that they meet the NE standard.
Right. Yeah, I think that's a good point. And, I think it's also important to keep in mind that, the NE is kind of above and outside of the regular visa requirements. So if you have the employee that is going to the interview, they're still going to have to qualify for the visa and meet all those requirements. And then in addition to that, they're going to have to meet the NIE standards. So, kind of just something addition to keep in mind there.
That's right. The other thing I think employers have to remember is that once you're granted the NE, you only have 30 days to use it. And it's only available for one entry. So, sometimes we're getting requests from clients for multiple NE requests for somebody that has to keep coming back to the United States. But timing is important. You need to look at the date of the anticipated travel, and then at the same time, make sure that you're using it within 30 days. The last thing I want to mention here is we could be sitting here a month from now, and this might not all be an issue. I know that just this week, President Biden, has been talking with government officials from Canada, Mexico, the EU, UK, others about trying to release or relieve some of these travel ban restrictions. The EU came out a couple of days ago and indicated that they were now going to permit US citizens to the country and releasing some travel restrictions there. So I think within the next month or so, we may see that this would go off the table, but at the same time, it is a work in progress. So we'll just have to see.
I think that's a really good point. And it's, I like you said, I did see that news that the EU had made kind of an advancement and kind of opening up their recommendation that United States travelers be allowed back into there. And you would think that it would kind of be reciprocal in that. in that stance. But
I'm sure there will be pressure to do that for sure.
Right, for sure. If we, so say you have an employee that is subject to the travel restrictions due to COVID, and they don't qualify for an NIE, what kind of alternative strategies have we been using with clients for that?
Yeah, one of the things that we've successfully used is maybe having them travel to a third country, like Mexico or somewhere else where they can get into the country. I mean, that's always important to consider that. Do you have the ability, depending on what country you're from, to get into that country? But getting in there, maybe riding out the 14 days and then coming into the US. So some clients have successfully used that strategy, which has worked, pretty well. So John, let's kind of focus our attention to another topic. One of the things that's been really big this year is the public charge rule and some changes along those lines. And I know that impacts not only green card holders, but also visa holders. But can you maybe talk a little bit about what's happened with the public charge rule and why that might be relevant to businesses?
Sure. If you follow the public charge rule really at all over the past, I'd say 12 to 18 months, it's kind of been in flux. It's all over the place. It went into place and then it kind of is getting blocked by court orders, and you have other court orders that are kind of conflicting. So it's really been kind of all over the place. It's nice that we at least have a little bit of clarity on it now. So before I get into kind of the current status on it, let me just back up a second and explain kind of what is the public charge rule. And generally what that is, it's a rule that a foreign national that's seeking some sort of an immigration benefit. So, we're talking about maybe a temporary visa or a green card. They're going to be considered quote unquote inadmissible if they are likely to become a public charge when they enter the United States. That kind of term, likely to become a public charge, never really had much of a definition to it in the past. And what we saw under the Trump administration was not really a new public charge rule. It was a new interpretation of what does that public charge rule mean. And under that new interpretation, according to the Trump administration, if you were a foreign national that had received one or more public benefits for 12 or more months in the prior 36 months, you were going to be considered a quote unquote public charge. And if you're considered a public charge, you're going to be considered inadmissible, which means that you're not going to be eligible for kind of the general immigration benefits that you would be seeking, whether it be a visa or a green card or what have you. So what were kind of the negatives that we saw to this from an immigration practitioner and also to our clients as employers? I think the biggest thing that we saw was a big time increase in processing times. The new rule required essentially a new petition, a new form whenever you filed a green card application that took multiple hours to kind of go through the foreign nationals' financial history, looking at whether they had paid taxes before, and ensuring that they hadn't used these public benefits in the past, and kind of going through the whole totality of the circumstances to confirm, okay, this person is not going to be a public charge. And in the past with employment-based cases, we wouldn't have had to do any of this because at the end of the day, they're qualifying for a green card because they're being offered a job when they come into the United States. So, the processing time from the attorney standpoint went way up, which obviously increased costs, but also, at the adjudication service centers, really we saw processing times go up as well. Because at the end of the day, the immigration officers that are there, they're not, they don't have a background in financial history and that type of thing. So it takes some time to kind of get through all these documents and understand what exactly is going on. So that's kind of the background of what it was when it was actually in place. As I said, there were a number of court cases that were kind of discussing the public charge rule. And ultimately, we had a court that struck down that public charge rule interpretation from the Trump administration because saying the Trump administration kind of went outside of their authority when they interpreted that rule, saying, you went a little bit too far is really what they ended up saying. Because there were ongoing appeals, the public charge rule was kind of still in place, even though it had been struck down by a court. Really, we're just kind of waiting for the final word from the appellate courts and the Supreme Court as to kind of how they were going to let that rule play out. But while all this was ongoing, we had a change in administration. So you had the Trump administration that put this interpretation into play, and then you have the Biden administration that obviously has different immigration priorities and that type of thing when they came into office. And the first thing the Biden administration did is they issued an executive order kind of across the board that said all administrative agencies need to review any new rules or regulations that had gone into place in the last, I think it was 12 or 18 months by the Trump administration, and that included the public charge rule. Well, at that point in time, what you had was the case was sitting at the Supreme Court, and you were just kind of waiting to see what the Supreme Court was going to do. The Biden administration obviously would have been the group to defend the rule. And what they kind of decided to do is to say, we don't think this, we kind of agree with the court that this rule kind of went a little bit too far. And as a result of that, we're not going to fight this any further. So ultimately, the Supreme Court didn't even end up hearing the case. It just got dismissed. So the lower court's order kind of went into place permanently. And as a result, that's why we don't have the public charge rule anymore. So what's the current kind of situation with it? It's just like it was before we had this, before this interpretation kind of came out with the Trump administration. Very, very little impact on employment-based cases, which is good news for employers that are looking to sponsor individuals for green cards and visas.
And John, would you say that's really the primary impact for businesses of not having the public charge rule, just not having to really, deal with all of this extra information that has to be collected, or what other effects do you think there are that now that this rule is no longer in effect?
Yeah, I think that will be a primary effect of it, but I think probably one of the biggest benefits that employers are going to see out of this is hopefully we can kind of get that wheel going if they have employees that are in the green card system, and it'll start moving again. I know, Melissa, you would agree with me that this rule, when it went into place, it really kind of grinded the green card process to a halt,
right?
Because everybody was really just trying to figure out how exactly they were going to apply this rule and how stringent they were going to be on it, I think.
Right. And when it really felt violative, it created some interesting situations, I think, for the attorney, because, you're getting very private information about assets and liabilities and health situations from employees. And, lo and behold, let's say that something that we were getting was, negatively impacting a case, and then you had to share that with the employer. So it really was an awkward thing. So I think we're both glad that this is no longer part of the process.
Right. Yeah, I definitely agree with that. And it just, it was, I think the other benefit that we're going to see from it is probably a lowering in costs to employers from, like we talked about, it took a long time to prepare that. So I think that it's, going to be a big benefit for clients to not have to go through what essentially was a tax audit. It felt like at times at the end of the day. But so let's switch gears a little bit here and talk about another kind of COVID related issue in the immigration realm, and that deals with I-9s and I-9 compliance and flexibility. And we've had this new rule that's out there that's allowing for some flexibility, and it's allowed for remote verification, and ICE is kind of considering permitting remote verification long term. What is kind of the status of that flexibility, and where do you think it's going to go from here?
Right. I mean, so since November of 1986, when the Immigration Reform and Control Act went into place, employers have had to do in-person physical examination of I-9 documents to satisfy the list A, B, and C requirements on the I-9 form. And that's always been, sort of the general rule. So now we go into sort of global pandemic times in early 2020. And thankfully, Department of Homeland Security sort of stepped up to the plate and passed this remote verification rule. And what it said is if a business generally is operating in a fully remote capacity, subject to quarantine or lockdowns, that there was an opportunity to sort of lay aside the need to do in-person verification and to permit verification remotely, maybe by a video link or scan or something like that. And so that was very helpful, when people couldn't get together. But as the rules sort of started to unfold, it became clear that it only applied if the business was operating fully remotely. And over time, most businesses came back, or at least their human resources or administrative team or something was working in the office. So it was hard to use the rule. Now we have, had a recent change on that. And what DHS has said there is that instead of focusing solely on the employer and the business, the employer's business and what's happening, whether they're remote or not, they are going to look at a particular employee hired after the guidance went into place. And if that particular employee is working fully remotely, it does say that the employer can use those sort of electronic verification means. And then once the employee returns, then they would have to go ahead and go through the normal process. Now, this only works, as long as the person's remote. If they're coming back to the office on a regular, consistent, or predictable basis, then they have to go ahead and switch back to the in-person verification. This remote verification, flexibility, I guess you could say, is in place through August 31st. We did hear that maybe there wasn't going to be an extension, and I think that really increased the antenna, put the antenna up for a lot of employers who thought that they were now going to have to suddenly shift to in-person verification for all these folks. But I've also heard reports that perhaps this will be extended. So we'll just, have to see how things unfold from here.
Right. Yeah. And I hope, I know I had a couple clients at least that were, getting really concerned as we got up to that last deadline, because they really haven't been giving us much notice at all when we get these extensions. It's only, a couple of days, and then all of a sudden everybody's gearing up. Are we going back? Are we going back? And then, we're going to extend it another 90 days or 60 days or what have you. But what do you think the chances are that we will see at least one more extension here?
I think it's very likely we'll see another extension. And I also think, we belong to the American Immigration Lawyers Association, which is a very active immigration bar and sort of group that really stays on the pulse of what's going on with government agencies. And what we're hearing is that there has been some pressure on the government to maybe even consider making this a permanent program, that making this sort of getting away from the need to do in-person verification. So I don't know if that'll happen. I haven't seen a lot of data yet on audits that are happening of employers, who maybe have done this remote verification and how that plays into an ICE audit. So I think there's a lot of questions and a lot of implications here, but I do think we'll see another extension, and I think there's certainly discussions that this may be the way things could shape up in the future.
Yeah. So you also you talked a little bit about kind of the focus on whether the employees return to regular, consistent, kind of predictable basis into the workplace. What are your thoughts on maybe some indicators that an employer might say, okay, we've kind of tipped the balance and that employee has kind of met that standard, as opposed to maybe they're just coming into the office to grab a file or something and then
right. Yeah, I think that's really it. I mean, I think if somebody's stopping in for an important meeting or something, maybe once every couple of weeks, or stopping by the office to get files, or attend a meeting or something, I'm not sure that would be that regular, consistent, predictable basis. But I think if somebody now has returned to the office, most of their working hours are spent there as opposed to remotely, then I think the expectation would be that within 3 business days of that, the employer needs to be switching back to that in-person verification. And, employers need to be aware of that, because that's how that works. You have the I-9 completed, that you've done the remote verification, but within 3 business days from when that employee returns to this regular sort of predictable, consistent schedule, then you do need to update the I-9 form in section 2 and indicate that you've now physically examined those documents. So that's a very quick turnaround time for an employer who maybe has lots of I-9s that they're dealing with. So the sooner that employers can start working back into that in-person verification, probably the better. Yeah. So it'll be interesting to see how that unfolds. But John, another thing that, we've seen just in working in the immigration space for a while is things do change with administrations that come and go. And, it seems like we're coming off of a long period of time where maybe it's been challenging, and it's been tough sometimes to get visa applications approved, or we've had, challenges in certain areas that we really maybe haven't had in the past. And, do you see any changes for employers there? Let's say it's an H or an L visa where maybe an employer got a really nasty request for evidence, RFE. Do you think that's going to change in the future going forward? And what are we seeing there?
Yeah, I definitely think with the priorities, kind of with the new administration, as you kind of said, immigration priorities tend to kind of swing from one end of the spectrum to the complete other end of the spectrum when you get a change of administration. So, and we've already seen a lot of different indicators that we're moving in the other direction from what would be a little bit more of a strict standard to what might be a little bit more of a favorable standard for employers that are trying to sponsor foreign nationals. And one way that we've seen that is with kind of the reintroduction with some what I'll call foreign national friendly or employment-based immigration friendly memoranda by the administration. And one of those memos is what I refer to as the prior deference memo. And what that is it requires that USCIS give deference on visa extension petitions. So why is that good? Number one, it obviously speeds up adjudication. So if you've had if you have an employee who's had their visa approved one time, in theory, they should still meet those requirements if they're up for an extension 2 years down the road. So it shouldn't be any sort of an issue. So we, hopefully we'll be able to get it through the system a little bit quicker. And it also provides kind of stability for an employer where, you've had this employee now for 3 years, they're coming up for an extension, and you can believe that they're going to be around for another 3 years, as opposed to, okay, here we go through the process again, cross your fingers, and hopefully it'll get approved again, and then they'll be able to stay on. So, from a stability standpoint, I think the prior deference memo is kind of a big win for employment-based sponsors. Another memorandum that we've seen that is kind of employer-friendly here is the reinstitution of the RFE before you get a denial. It's just a memo that essentially requires USCIS in most instances to issue a request for evidence before they deny any sort of an immigration benefit, like a visa application or a green card application. And when you file these applications, there's a lot of time and energy that's gone into it. And at the end of the day, people are only human. Sometimes they make mistakes, or so something might need explanation to the immigration office. And so what this memo does is it kind of gives you the opportunity as an employer not to just get an outright denial immediately, but to kind of explain, oh, maybe you misinterpreted exactly what we were saying by this. Maybe this is why this individual meets the particular visa requirements that they're applying for. So I think that is just another example of kind of how we're going to see things swing a little bit more towards being employer friendly here in the next few years. I think we'll see adjudications in general be a little less strict. You always kind of have that discretion that an immigration adjudicator has when they're looking at an application. We've really seen RFEs increase substantially over the last few years, and that obviously increases costs for clients and that type of thing. But I think, at least in my mind, we've already seen that kind of relax a little bit in the last few months that we've had. We're seeing a lot less requests from the immigration office in general. So I think what we'll probably see there is a little bit more of a return to kind of normal numbers that we've seen in the past in terms of kind of additional requests from the immigration office and that type of thing.
Yeah, what do you think about the processing times? I know that a lot of employers struggle when they're waiting for decisions from the Department of Labor or USCIS. Do you anticipate that there will be any changes in the processing times?
I think that they'll get better than they are right now. It's kind of no secret right now that it was kind of the perfect storm with some of these new rules that went into place under the prior administration, plus COVID hitting. We've seen a lengthening of adjudication times and processing times kind of across the board. But Melissa, you'll remember we were on that ALA call last week, and there was kind of some talk of maybe getting some additional funding at the Department of Labor and that type of thing, which would hopefully move perm applications a little bit quicker. There has been some movement from USCIS on suspending biometrics requirements for visa applications. So, it's just one less step that you have to go through in the process. And, we've also seen with our own clients that USCIS is kind of waiving some of these employment-based interviews in some circumstances, which may be a COVID thing, but also may be more of a permanent thing because, we didn't used to see the interviews in the employment-based context really until the last, I'd say, 3 years or something like that. So hopefully that's something that'll go away, because really what it does is it's just kind of slowing down the process, I feel like, in the end.
Yes, I agree. And we've also seen on like the family-based applications in the visa space, when a 539 is filed or something, we've seen deleting the biometrics requirement for that as well. So I do think we will see some speeding up of the processing. I will say though, the Department of Labor, still seems to be struggling with funding and didn't give a lot of optimism on increased processing time. So for those businesses that are dealing with green cards in the perm process, you may continue to see just month-long delays there that we wish would get better, but who knows? John, what do you think about embassies and consulates? You've talked about some of the loosening up of restrictions at USCIS on petitions and changes in various rules, but do you think that will also carry over to consulates and embassies, maybe as it relates to e-visas or blanket L processing?
Yeah, I think there's a good chance that it will, because I think it's kind of the, I think you'll see a little bit of the trickle down effect that, it's coming from the administration and not necessarily to the individual agency. I think that's good news because, the E2s and the blanket Ls are really a big benefit because for a lot of employers, because you don't have to go through the immigration office and get a prior approval before you can go and get an appointment at the consulate right now. And, I think that is even more so a benefit right now because we're seeing such long consulate delays. It's kind of still hit or miss a little bit in terms of being able to get an appointment. Do we need an expedited appointment just based on the COVID restrictions varying so much all over the world right now. And obviously these different consulates are, in various places all over the place. So, I think there is a good chance that we'll see some restrictions kind of loosen up on the E2 and the blanket L. And I think that's more good news kind of moving forward here. So.
Yeah, I agree. All right, so I think the last thing we want to cover is on comprehensive immigration reform. And John, I know we've heard a lot about comprehensive immigration reform proposals and things over the years, and that's certainly something that's been on President Biden's agenda. We've heard a lot about it, but what are your thoughts? Do you think that this might be the year for comprehensive immigration reform, or do you think there's a particular aspect of comprehensive immigration reform that maybe the Congress will focus on?
Yeah, like you said, it seems like every 4 years we get kind of the new hope that we're going to get some sort of immigration reform, and it never quite seems to pan out. I'm hopeful that we'll see something, but I think it's more likely to come in a little bit more of a piecemeal way. One thing I think is probably going to be on the forefront is maybe the H1b reform. We'd seen the prior administration really kind of ramp up some rules. And then as part of that, the agency rule review that I talked about earlier, we saw those kind of get suspended by the Biden administration. You have that, there was a new rule in terms of being selected for the H1b lottery that really kind of push it more towards individuals that are being paid more would have a better chance to get selected in the lottery. And that has been delayed until the end of this year. Who knows, that could be delayed further. And then there's also the wage increase rule for H1Bs that was originally supposed to be in place for this past lottery season that we just kind of completed the selection for. That's now been delayed through November of 2022. So, that it's important to keep in mind, yes, from an immigration reform standpoint, that that is out there, but it's also important because employers are going to kind of get one more shot at these current wage rules in the H1B lottery in April 2021. So I think H1B will be one area that you'll see a focus on, and I think DACA probably will be another area that will, at least I think that we'll probably see as well, hopefully some sort of movement towards a permanent residency for them. But what do you think about it?
Well, I mean, I agree with you on the DACA and the Dreamers. You know, you've got those two bills, one in the House and one in the Senate, that deal with the Dreamers. And you know, those are the folks that came in as children, essentially, most of the time illegally with their parents under the age of 18. And, you know, they have a right to a public education up until the age of 18, but beyond that point, then they suffer real ramifications in terms of trying to get a job or going to college because of their status. And so, you know, this DACA program John mentions, I do agree that, you know, last year the Supreme Court said that DACA program was upheld, but we know that that's also under challenge right now with that litigation in Texas. So I do think that the bills that are pending right now show a movement and maybe some bipartisan support that there will be some relief for these DACA or Dreamer students. Is that legalization? You know, is that getting a green card? You know, and if so, what does that look like? I don't know, but it seems like that could be an area where there could be some focus. The other area that I think possibly could be, you know, maybe a part of that comprehensive immigration approach that would be broken apart and maybe focused on by Congress would be some relief to green cards, maybe even employment-based green cards. This U.S. Citizenship Act of 2021 and sort of that Biden proposal, you know, had several things related to that, where they were going to increase the number of employment-based green cards from 140 to 170,000. They were going to, for those green cards that weren't used in a particular year in some categories, they were going to recapture those and apply them to maybe categories where there had been overusage. Any business that, you know, works in the green card space knows that for Indian and Chinese nationals, they're waiting sometimes more than 10 years to get a green card. So, you know, I think could be some relief there. The other thing that they're looking at is when they look at the numbers of people that are counted towards the 140,000 allotted employment-based green cards, not counting spouses and beneficiaries, which would make, you know, more employees eligible for those green cards. So I think we could see some things there. I agree with you. We could continue to see some changes on the H1b. You know, will we see a comprehensive legalization program for 11 undocumented people? You know, I don't know. I think that's going to take some real work, and obviously the Senate and the House having to come together on that. So I think that could be a longer term priority, but short term, maybe some piecemeal movements in these areas.
Yeah, and just a quick comment also on the Indian and Chinese nationals that you were kind of talking about. You know, we've really seen a lot of good movement on the visa bulletin this year. For those of you that don't know, that's kind of the document we use to determine when these Indian and Chinese nationals will be eligible to actually get a green card, and kind of some unusually quick moving progress towards getting a green card this year. So that's kind of some good news for a lot of employers out there as well.
Yeah. Well, we appreciate your time today. And if you have any questions, feel free to send them to the Q&A box or the chat box, or John and I, our information is available on the website. If you'd like to just email us privately, we'd be happy to answer anything. But we hope this immigration update's been helpful. And we look forward to joining you again and giving you an update in the future. And don't forget to check out our podcast and our blog. So thanks for joining us and have a great weekend.